Well, good morning, everybody, and welcome to this latest session with the official injury claim. For those of you that haven't met me yet, my name is Martin Saunders. I'm head of service. Some of you will have expected to have seen Dominic Claydon, our CEO, here today. Unfortunately, Dominic's diary didn't permit him to attend, but he sends his good wishes to everybody, and I have every confidence that he'll be picking up with you all at future events. We're now getting really close to the 31st of May, 31st of March, 2 months away, and preparations on all sides are now getting to quite an advanced stage. What we're doing today is we're walking you through the latest in a series of conversations that we've been having in order to help some of the education process and understanding of how this new service is going to work. Today, we're going to be focusing on the compensator's journey. Most of you that have seen some of these sessions will understand that we've been looking at it to date from an unrepresented claimant perspective, so concentrating a lot of the inputs that come into the service as opposed to the responses that are actually made. So today we're taking you through the service at the point where all of those inputs, here's my claim, this is how the accident happens, this is what I'm claiming for, things that you've seen before. We're not duplicating, we're trying to make best use of time, and we're looking at it, as I said, from a compensator's viewpoint. Now, that doesn't mean to say that if you're a professional user, if you're a claimant lawyer or a CMC that's permitted to use the system, or indeed if you're a DME or sitting in an MRO, that we're excluding you today. We're having conversations both with MAS, looking at this from the lens of a professional user, and you'll be hearing shortly with confirmation of an event that's being planned for the 15th of April. So that will be coming out as a flyer from the MAS team now very quickly, and we'll be having the conversation with your lens that's actually in focus there, not exclusively, but obviously your lens. And for MROs, DMEs, there's ongoing conversations with the MedCo organisation around some of the education that needs to happen in that space. So more of the work that you've seen from us, looking at some static screenshots of registration, of how you get onto the system, how you upload medicals and so on. We'll also be doing hopefully some additional videos, some camera work, so that you can see the system and actually get access to it as well. So MedCo's working with that, and they're owning that space. MAS are owning that space, and obviously we're contributing. So what I wanted to do today, and I wanted to talk to you about the agenda that we've got promised for today. So if we look ahead, the things that we're going to cover, this concept of a work basket. So how do I get my work? Where does it come into? How can I allocate and reallocate work when it comes into me as a compensator? We'll be running through liability decisions, how you're making them, how you're conveying them, and we'll also be covering the offer section to the claimant. And again, all of these areas of the build are dealt with as a sort of a to-fro flow that you will have hopefully by now come to be accustomed to. We're also dealing today with exiting from the service, and I think it was on the I think it was the 1st of March when we did the first of these seminars, where I showed you a very quick glimpse of some of the material that you haven't yet seen, which was some of the court forms that are auto-populated. I've also got in here some of the medical screens that we can use as well to see how medical instructions are populated a bit later, but that's some of the material that's going on in the background of the system as users input material that's going to be used. It's going to be scooped up and used at a later point, albeit at that medical journey or a court exit point. And we'll have a little look at that today. And then finally, we're going to cover looking at additional medical reports, and we're going to tackle NVCs. Now, you'll be aware that there's an awful lot that's going on in the background of OIC at the moment, not the least of which is for making the system available to users next week. I'll come to that after our demo. Our demo is recorded today, so it's going to be walked through on a pre-recorded basis. Those recordings and this recording will be made available afterwards so that we can again come back to this and have a look at it, play it back, learn it. Did I understand that? Did I understand it correctly? So that we can actually sort of deal with it in consequence. And the reason why we've done it as a demo today that's pre-recorded is that I just wanted to reduce the risks that sit back within the build at a point in time where so much was going on. So I can only apologise that we were going to do a live demo today, but it is pre-recorded for the very best reasons. For this session, Q&As were opened on Slido in advance, and we've received lots of questions, so thank you very much indeed for those of you that have already contributed. Once we've done the demo, I'll be doing I'm going to try and knock out the top 30 most popular of those Q&As in order to give us all a flavour as to what's being asked and what's on the front of people's mind. We have actually seen a lot of these questions ever so subtly turn, and I think that's tribute to the most significant number of people that are actually now commentating and helping with the way in which this system is working. So those are professionals in your own right, in your marketing departments, who are now pushing out details of PAP and PD and build, and generally sort of enabling all of us to have conversations that mean that some of those easier questions are now becoming common knowledge, and some of those grittier questions are coming to the fore, and we're tackling those as we require to. So at the end of QAs, I'm then going to reopen Slido. I'm conscious that we'll have had a conversation by that stage of about 40-45 minutes, and you'll have learnt more and you'll have questions as they come on. We won't tackle those today, but what we will do is we'll again take those away. We'll look at the themes, we'll look at what's already been asked, we'll compare them against the FAQs that have already been published both in this forum and by MOJ and other forums, and we'll just make sure that those themes are covered off and dealt with in the days, the week ahead. And then finally, what we'll do is I'll come back on screen at about 11:15, and I'll just share with you a little bit about what's going to happen next week. So that's the week when we say, come onto the system, start training, start getting more familiar than you are at this point in time, and again, what we can do is we can take the service forward. So hopefully that's covered things off around what we hope to achieve today, and hopefully that matches everybody's expectation in terms of the way in which this latest session has been framed. But what I wanted just before we get into the demo is just quickly just to highlight again, this is a slide that I think you've all seen before. So MIB's role and remit is, as the sort of neutral build, delivery and operational partner of MOJ. So things of policy are not ours. Obviously, we're aware of debates, conversations that are going on, but our role is very much to put that into practice and to convert that into the system that everybody will be getting familiar with. And our masters, the MOJ, are responsible for putting that policy into place. I wanted just to leave you with one final static slide before we go into demo, which is just reminding us around the communications that we said that we would be putting out during February and March. We're pretty much on schedule for what we said we'd do. We've obviously had various webinar events with yourselves. We've dealt with FAQs and the questions that have been asked of us. And what we've also been able to do is we've been able to put those spotlight demos out on a piecemeal basis as we've been going through March in order to give people ideas of the concepts and what's coming up. So there's some more of that material that's going out at the end of this week, over the next day or two, in order to complete that deck. And what we're doing is we're reviewing FAQs and feedback in order to understand whether or not there's more of those that we need to do. They're actually getting some really big hit numbers in terms of views. So I think that material is sinking in. And again, as we go into next week, that's going to be part of the toolkit that everybody will use, which will enable you to go back and not just sort of get stuck in where you are on the system, but actually look to see how that works and what should be doing. So if I can leave it there for the moment, we've got a video that's going to play, as I said, for about, I think it's 28 minutes is the video. So Ryan, hopefully if you can cue that up and we can go straight into that part of today, please.
Hello, we're going to be looking through varied paths that the compensator will see through the portal. This is the first video and we're going to have a quick overview of the work baskets and other items that you can see on the page. So we're currently on my team's work tab. This is a list of claims that has been assigned to my team. We can see the organisation's work, which is going to be across multiple teams. Any resolved claims are stored under the resolved claims tab. And we can see anything that I've seen recently as well under my recent work. You'll also notice that we have the filters option where you can search under varied information to filter particular claims, and dependent on the credentials for the user, you're able to move claims and assign ownership to a particular handler or team. After you select them from the checkbox, the claims through the checkboxes on the left of the list. And the organisation administrator is able to add new offices through the Manage Organisation tab, new users through the Users tab. You're able to see any third-party administrators that you're paired with under the Third-Party Administrators tab, and also you're able to organise the claims routing for particular claims under a particular MID ID and via the policy level contact code via the MID routing table tab.
Good morning. We're now going to take you through where a compensator has received a claim from an unrepresented claimant and they need to make their liability decision. As you can see, we're in the compensator view and we have your list of work. The new indicator informs you that something new has happened on that claim. Under the status heading, you can see that there's a variation of different statuses at different variations of the claim process. We're going to be looking at pending liability. So as I've said, the unrepresented claimant has already submitted the claim to me, and I now need to make my liability decision. Master provider reference number. And general information for the handler dealing with the claim. And now I'm going to select my liability response. In the drop down, you can see we can admit liability in full, liability admitted in part, liability denied, or dispute accident caused injury. If we are to select liability admitted in part, we then need to select the capacity with which you'll be acting on this case, and you will see there is a liability percentage that is admitted by the compensator. Upon selecting continue, I'm asked the questions: was the client wearing a seatbelt, and does the defendant agree? If I'm to select no, I'm asked, do I have the dependent's version of events? If I select no, I'm then asked to provide a witness summary. You can add a summary of your facts here. This will be shared with the medical expert. I'm then asked to check the contact details of the defendant. We then are presented with a review screen where you can review the information you've added by clicking on the arrow. If you want to change this, you can select the change button and you can go back and change your decision. Then provided with a statement of truth. Upon selecting accept and send, that claim has now gone back to the unrepresented claimant, where the compensator has made a decision of a 50-50 split liability.
Here we're going to be looking at the offer stage of the process. The claim we're going to be using is the one at the top of the list. This claim has already had a liability admitted in full. The claimant's obtained their medical report, which has now been sent over for the compensator to review. The first question we're asked is whether we want to make an offer based on the medical report. If we say no, this takes us down the route of disputing causation. If we continue from this stage, we can dispute the claim in full, or we can make a final offer for the other protocol damages. We'll go through and treat this as if it's a claim we're not going to be disputing causation. So we will make an offer. We're then given a review screen. and then we're taken into the create offer flow. We can provide the crew reference, and then we're given an itemized list of all the losses that can be claimed. This excess field has a financial figure against it, so we can make an offer against that head of claim. As you'll see, the grey box is updated when we add financials into the fields. We're able to give an offer for the tariff amount. And any non-tariff injuries. We can enter any deductions if there's any if this was a partial liability case. We can factor that in here. And again, if there was any argument regarding seatbelt, that'd be factored in here. And we've got interim and crew deductions within the next section. We're then asked if we want to round up the offer. So the example we have, the amount's £900, but if we're going to say yes, we want to round it up to £1,000, we can add £100 for the roundup, apply, and then that gets factored in into the offer. Then give it a summary screen. We've got the change options on the right if we wish to change anything. We continue. We're then asked to complete a statement of truth and confirm our job title. And if we click save and send, our offer will be sent to the claimant for review. And that brings this section to a conclusion.
Now we're going to look at a point of removing a claim due to an exit reason. So we're going to say that I've got some further evidence on this claim, so I now want to remove the claim from the portal after previously making a liability decision. If you scroll down to My Other Actions, you will then see you have the option to remove this claim from the portal. Upon selecting that option, I'm then given some further instructions so I can remove the claim from the portal. I want to confirm that I want to do this. Upon selecting I confirm, I'm then presented with 5 reasons why I can remove this claim from the portal. If I don't want to do this, I can click cancel and it will take me back to my claim overview screen. Upon selecting the option, I'm then presented with some further information and instructions, and then I can give my reason at why I want to remove the claim from the portal. As you see, upon selecting a different radio button, your reason or issue changes the reason of the box. I'm selecting continue. I'm presented with a review screen. At this point, I can still cancel, or I can go back to change my decision. I'm selecting remove. As you can see, I've removed the claim from the portal and the claim is now closed. And the unrepresented claimant would have received a message to advise them that something has happened on their claim and they need to log into the portal to see what that action is. And that's the end of the exit demonstration. Now we're going to show you how an unrepresented claimant can obtain or request a second medical report. Now we're in as the unrepresented claimant. They would select obtain a further report and continue. So they're then given options. They can either obtain their own report or they can request for the compensator to obtain this for them. We're going to request a further report. We're then given a drop down with 4 options. So we're going to say that it was recommended by a medical expert. We then ask if the medical report is to be shared with the compensator. If the user selects no, then that medical report will not be shared with you as the compensator. We're going to select yes, and we've just put in some reasons why a further report is recommended. Again, we're presented with a review screen. Selecting the arrows provides you with the question and the response, and they can go back and change anything if required. Upon selecting confirm, that has now been sent to the compensator. I'm now logged in as the compensator, and I've got a claim here, pending decide new medical. Upon selecting that claim, you can see that the claimant has requested a further medical report. If I select review request, I'm then shown the answers and along with the questions why the claimant is requesting a further medical. As you can see, do you want to object to the request for a further medical report? On selecting yes, I'm then asked to provide my reasons, which upon providing my reasons for not agreeing to a further medical, that will be sent back to the claimant and they will be asked how they want to proceed with their claim. Upon selecting no, I'm acknowledging the request, selecting finish. I've then, as you can see from the screen, we've agreed to instruct a medical expert to assess the claimant for a further report. A copy of the instructions will need to be uploaded to the portal, and you can do this via the My Documents section and the Upload Documents, where you can add this to the portal. That would also need to be sent to the medical expert. That is the end of the demonstration on second medical. We're now going to show you a demonstration as a compensator receiving a claim from the unrepresented claimant for non-protocol vehicle costs and the journey to court, from showing both personas from the unrepresented view and the compensator's view. As you can see here, the claim is pending an NVC response. We can see here that we have a new indicators showing as new losses have been added and new documents. And we're now going to proceed to the response. Here we're presented with the non-protocol vehicle cost questions that the claimant has answered. Along with the categories and the description of the items being claimed and their values. As a compensator, you will be asked if you dispute the non-protocol vehicle costs. Upon selecting yes, you're asked to confirm that you've uploaded the non-protocol vehicle cost response document. For today's demonstration, we're going to select no, that you're not going to dispute them. Then presented with a review screen to confirm that you're not disputing and that you haven't uploaded the non-protocol vehicle response document. If you wish to change this, you do have the back button that will take you back to the previous page. Upon selecting finish, this has now been passed back to the claimant, who has decided to go to court, and they will include this within their court pack. Now I'm logged in as the unrepresented claimant. Upon selecting view details, and then presented with a page preparing for court, which references the tables within the pre-action protocol for the reason for why I'm going to court and the documents relating to the tables that I'm required to present to court. Now here I'm able to select my documents that I wish to create my court pack. The review screen, where upon selecting the arrow, will then show the 7 documents I selected. If I want to change anything, I can click change, or I have the back button. Upon confirm and send, this is now sent the documents to the compensator to review. I can now see that the claimant has selected their documents for court, and for me to review these, I'll click View More Details. Here I'm shown the documents that the claimant has selected for court. And I'm given 2 options: do I agree to the document selected or not? Now ask information regarding the defendant's address for service, and do I wish to nominate a legal representative to accept service? Upon selecting yes, we can add the firm or organisation, their reference number, their postcode. You can either type in their postcode and click Find Address, or you can enter their details in manually. If you were to select No and continue, you can check the details of the court pack, defendant's address for service, confirm. That's now been sent back to the claimant to continue with the court process. I'm now logged back in as the unrepresented claimant. The compensator has reviewed the documents that I've selected to court. The confirmation screen of the documents that have been selected. To confirm the claimant's the defendant's details. If I select yes, again, with the postcode finder, it will pull up the address, or I can enter the address manually. If I select no, then it will pull through the insurer's details. Next screen the unrepresented claimant is presented with is regarding the hearing centre. Are they aware of any court proceedings that are already underway? If they were to select yes, they're asked for the existing claim number, and if they require any special assistance. Select witnesses. If there were any witnesses here, they can select their witnesses, or if they have any witnesses that they haven't previously advised, they can add them now. Court pack evidence. So this is now asking if there's any additional evidence that they wish to rely on. If they were to select no, they would then be asked further questions regarding any new evidence they want to rely upon. Non-protocol vehicle costs. Court fees payable. So the court fee payable is for a claim valued up to £1,000. We have in the grey box the details of the claim so far. As you can see, we have the non-protocol vehicle costs, other protocol damages, damages for injury, and the total amount claimed. Check your answers screen. Again, we can go back. The arrows expand the questions and the answers. And we have the change button that we can go back and change. Confirm and send. The court forms have now been created. What happens next? So instructions to the unrepresented claimant on what they must do next. The claim has now gone to court outside of the portal and await the final court decision for the agreed damages to be paid. This is the end of the demonstration of non-protocol vehicle costs and the court process.
Okay, so thank you very much for that attention. I hope that you found that interesting. It's obviously a part of the system that we haven't shared widely previously, but it builds on the concepts that you've seen before. So the journey is intuitive for us as professionals. We understand how we manage to navigate our way through this system and through the claims journey. Questioning is again conditional, so dependent on how you construct your question, your answer depends on where the next part of the screen opens up to you or doesn't, just to improve your journey. And just as a reminder that the recording is going to be available after this session and distributed in the usual way. So thank you very much for that. What I'd like to do is the guys are going to reopen Slido in the background. I think that's going to take them about sort of 15-20 minutes in order to engineer, and they'll deal with that from about 11 o'clock. And the Slido reference and questionnaire, sorry, the code and the QR code will actually come up on the screen in front of us. So that if you've got anything that you want to ask either during the course of the rest of this session or indeed later when we go on off air, then please let us know. Otherwise, I think what we're going to try and tackle now are the top 30 questions. I want to probably cut this at around 11:15, 10 past 11 in order to sort of make sure that we've had a decent discussion around next steps. But if we can get through the top 30 during that time, let's attempt to do so. So Simon, is this your cue?
Yeah, sure, no worries. Okay. Okay, so let's just go straight into the first question. In contrast to part 4.7 in the PAP, the PAP is silent as to the path should a claim exit under part 11.6, where an MVC puts the overall value over £10,000. Does the claim continue under the RTA protocol if in scope, or can the claimant litigate?
Okay, so obviously there's an element of familiarity around what the protocol now exists. So I think the first thing to say is that you only reach part 11 having gone through the entire negotiation process, and during the course of that process then a number of claims are likely to be either resolving or narrowing issues as between the parties. So you only consider NVC at the point that you've been able to unable to resolve the portal claim. Otherwise, it's outside the scope of the portal. So if you go to the RTA PAP, the other one, they're also out of scope, as will the injury claim be, as it's below the £5,000. So if you then add NVC at section 11 and it takes it over 10,000, then as a claimant you need to start proceedings in part 7. So a bit of a long answer. I see that actually I think the question has been asked previously, so hopefully that's now dealt with it. I suppose when we were having a look at this one of the considerations that I did have was that, well, what if somebody started their claim early? You know, is there a reason that they could otherwise have not dropped it out before having the negotiation and go straight to part 7 because it's, you know, a £4,000 injury claim and a, you know, £15,000 something else. And I suppose in theory they could, although obviously it's not certainly in accordance with how the either sets of protocol actually want to engineer it. So how the courts would deal with that and what they would look at in relation to costs and potentially parties not engaging in the negotiation process is probably not my call, but certainly the concept here is that you narrow, you go through that negotiation, and it's only until such time as you finalise that process do you then consider that overall value above or below 10,000.
Okay, next one. If a claimant moves from one representative firm to another, does the new representative firm take over the existing claim on the OIC portal, or do they have to start again with a new SCNF? What if the claimant instructed a law firm having started on the OIC as an unrepresented claimant?
Okay, so there's no mechanism at all within the OIC portal for change of representation, or indeed for adding a representative to an unrepresented claim. This was this was edict that we had fairly early on around how this should be built. So in those cases, the existing claim on the portal, so lawyer A, lawyer B, so lawyer A would have to withdraw their claim on the portal, and the new representative would start the journey by putting the claim back on the portal again. What the portal does have is it does have a print download facility, so that any information evidence that's already been uploaded can be reused, so that isn't lost. But do I need to start the journey again? Yes, you do.
Okay, thanks for that. It is not clear how long a compensator has to pay for a medical report before it is deemed to be overdue. In order to maintain their obligations to the court, experts need to be paid on set credit terms. Really a question, but
yeah, I think there's actually a series of medical discussions that came up in the top 30. I've not seen a definitive set of days in order for compensators to be paid. Obviously, from a bill perspective, OIC actually doesn't cater for payment of medical reports, so it's not an issue that it's had to front into. Payments, as we'll probably discuss later, happen outside of the system itself, and it's something that obviously as a policy decision I can't help you with, because I don't know the answer to that particular question.
Is there a plan to provide API JSON examples at each stage? It is becoming increasingly difficult to test. The data dictionaries do not match the expected JSON, and the expected JSON does not match the web user journey.
A very similar question was actually asked at an ABI session that I attended last week. And during March, we've been issuing a number of API almost weekly updates to you around what's coming, when you can next expect it. So the short answer here is yes. The next release of what's been termed Sprint 34 is on 7th of April, and those latest API JSONs requests will actually be sort of put into the public domain. I asked the ABI community that I addressed, yeah, it was last week rather than earlier this. I get confused these days. It's easily done. But if we can come up with specifics of where data dictionaries aren't matching, then it will be really useful for us as a service in order to deal with that and front into it, because if it's not matching on your service, then it's likely that it's not matching elsewhere as well. So we've seen some areas where the matches haven't happened. We are working our way through those, as you would continually expect. So I don't know whoever asked this question, but if there is detail that sits in the back of it that's still outstanding, if you can fire it into us, we'll do our best in order to resolve it for you as quickly as we can.
Great. Okay. Back on medical reporting, for LIPs, if the compensator challenges the medical report, do they retain responsibility for payment? Okay,
so the medical journey for an unrepresented claimant isn't triggered until such time as there is a liability determination. So on this system, you have to have either an admission in part or an admission in full, or have a dispute, leave the system, come back into it with a court saying that there is a responsibility for you, and the medical journey is then actually opened. So at that point in time, the compensator is essentially responsible for that fee as part of the journey. and as part of the instructions that the DME and the MRO get in advance, they'll be told of the admission, and they'll also be able to ask any relevant questions that arise at that point in time.
What evidence will be needed for a compensator to have the portal help desk agree to redirect the claim to the MIB as uninsured?
We struggled a little bit with this question because we thought it's highly unlikely that a compensator would actually be directing any uninsured claim to MIB. We think that we interpret this question in New World rather than MIB getting the claim as either an uninsured or untraced application. So if I've got that wrong, whoever's asked this, please get in touch and I'll deal with it. But if a compensator is faced with a claim and wants to dispute policy liability, they will have to resolve that as between the compensator and the claimant. The concept here was broadly that the claimant, the unrepresented claimant, wasn't going to be left without a route to having a dispute with a compensator. But if and when they have that dispute with the compensator, and the outcome is that the claimant has failed, for instance, in his claim against that particular compensator, then obviously evidence against that failure can be made against the MIB in the event of the compensator being proved correct, and then the litigant in person, the unrepresented claimant, can continue his journey with a claim directly against the MIB in those circumstances.
Will the MedCo offer for LIP include randomisation of MROs as in the current offer? SOLs have this break the link between those who commission reports and MROs who produce them. LIP are one-time users. Why not offer all MROs or have a taxi rank so each MRO gets the next LIP in the queue? Okay, so obviously really MedCo MOJ policy issue type question here. What I do know is that there was, I think it was last Friday, MedCo did publish a refreshed full set of criteria for that offer, which has changed from how question 7 has actually been framed. So really questions relating to this issue should be actually directed towards MedCo. They're not shared or debated with this service in advance as policy decisions, and all that OIC is doing is using the MedCo facility as anybody else would. We've got a few on this topic. So, yeah, there's a few that are similar, aren't they? I just sort of, yep. Yeah, so the next one is it should be clearer to the LIP that choosing an MRO will most likely result in a far wider choice of appointments, and as such should be promoted clearly in the offering. LIP should be directed to MROs before DMEs. Yeah, so really sorry, but I can't get into the debate of how MROs or DMEs are expressed or how their services should be offered. That is an issue for MedCo. I am an end user of the system, so all that I'm doing as OIC is I'm collecting information and I'm making the connection between the information collected. So what are my injuries? Where do I need to be seen by? Do I have any particularly strong preferences as to how that examination should be conducted? And then I'm pushing that into the MedCo system for the MedCo system to give me the offer. So I can't deal with that particular question either, I'm afraid, Simon. Maybe this one as well. Where a claimant selects an MRO but then does not want to proceed, or no contact can be made with the claimant to arrange an examination, does the case need closing on the OIC portal, and who is responsible for this, and after what time frame? Yeah, I think the first part of that question is much the same as the above, but the second part of the question I can help with. So from an expert's perspective, they only ever have to close the claim on MedCo as they do now, and it's not going to be the expert's responsibility to close the claim on OIC. That's a responsibility that ultimately the compensator will hold. if the compensator is forced to dispute liability where there is not the contract, where they are not the contract insurer, but the process porter does not allow redirection or rejection, when the court finds in the compensator favour, where will this leave the claimant with the process?
Okay, so I think this is again a part of a series of conversations that ABI members have been quite interested in around mid-referral processes and failures, and that conversation, as I said, is real and is happening. But there is an option to redirect prior to denial if the compensator knows who the correct insurer should be, and that option is actually to talk to the Portal Support Centre, and the Portal Support Centre does have the ability, with both compensators agreeing, in order to redirect the claim appropriately. But if the compensator, and I think we've partly covered this one already this morning, but if the compensator succeeds at a hearing post-denial on the basis that their insured is not the correct defendant, then the claimant has the opportunity to start over again against the correct defendant if they have those details, and they should have by that stage.
Okay. Will the MRO receive the MedCo reference with the instruction from OIC to arrange a medical?
In short, yes, but slight caveat. So if the MRO gets the instruction, as they do now, from a professional user, then whatever information, however they get those instructions, will continue as they presently exist as of today. And for unrepresented cases, OIC will ask MedCo for the standard offer, and once selected, then those instructions get sent directly. So both the MedCo and the OIC references are shown in the work basket, the concept of a DME MRO work basket that we've touched upon today, that are held in the OIC system. So it's all there, ready to be looked at.
Okay. And will there be a standard medical report template used for OIC?
Yeah, we've tried to. In fact, it was members of the CPRC subcommittee that were advocating this quite strongly, that there will be both standard medical reporting templates. I think something called RTA3 is already been in use for some time, although there's some slight variance in it depending on the software that some MROs use. So standard medical templates, so that we understand what the report looks like, and actually standard forms of instruction, which, depending on time, I've got a static of what that looks like. I won't do it partway in this flow. So the broad concept is that we will have a form that is pre-populated with the information that is provided on the injury, both in terms of what the system says and then the additional information box that the claimant gives you. The doctor might be asked about seatbelt, he might be asked about accident circumstances in order to deal with some of the more narrower areas that compensators would want to explore in this area, but it's all set out on a form. And the reason why it's all standardized, both in terms of reporting template and in terms of instruction, is not for us as professionals in this area, because we'll get really used to it really quickly, but it's for an unrepresented claimant. So the unrepresented claimant gets to see in advance how that medical examination is going to be conducted, the type of questions that they're going to be asked, and obviously once the report comes in, they're going to be asked to approve that. And then again, I think we've got some questions later on dealing with release of the report before it's actually shared with the compensator.
Okay. How will MRO's invoices be identified by the TPI? Will they need the OIC reference, MedCo reference, TPI reference with the report invoice?
I've already mentioned it. So invoices will get paid outside the system. what the system does hold is confirmation of who the compensator is, so that the DME MRO knows where to sign and send that invoice. Do I expect that references will have to be shown? I think that's pretty standard business etiquette. So certainly invoices and references should be shown in order to help those conversations along, but the payment itself is made outside the system.
And if the claimant does not attend a medical appointment, who pays the DNA fee?
Yeah, there's a presumption here it's the compensator, but I don't believe that there is a requirement on the compensator to pay that. So I don't think that presumption is correct.
How do you suggest we deal with pre-existing injuries, i.e. the claimant's back condition, which has been exacerbated by the accident? Would we value this based on the tariff plus up to 20% uplift, or would we make a JCG offer as we do now?
Okay, so there's much broader debate about how a mixture of tariff and non-tariff injuries are dealt with. That's outside of this conversation, but parties will be aware, particularly if they attended the MOJ seminar where that aspect was particularly touched upon. But tariff, which is obviously as a whiplash injury as defined, and there is a definition within the protocols, for an injury less than 24 months, needs to be correctly identified, and tariffs are there and described as amounts rather than offers or awards within the OIC system, in order to highlight that they are a predetermined set amount that are dependent on injury duration. So, as far as tariff and negotiation is concerned, there's an important point to be pulling out here, that you cannot negotiate on a tariff amount. It's a set award, a set determination, just triggered on the back of how long that injury is dealt with. But as I said, there's a broader debate going on around how the injury, when there's both tariff and non-tariff involved, as I think this question is actually suggesting, although whether you call a slip disc a whiplash injury, I think it would be under some debate, but that will clearly be dealt with in the coming weeks and months ahead.
Is there a size limit for document uploads to the portal, and what document types can be uploaded?
Yeah, I had to go and ask the techies for the answer to this one. So the size limit is 30 megabytes. And then there's a whole raft of file types, the majority of which I didn't understand, but things like TIFFs, PNGs, JPEGs, DocX, ODT in Word, etc. So we'll post the answer to that question. I won't run through the entire list here because I don't want people asking me what they mean, because I wouldn't know the answer. But certainly if anybody wants confirmation of any of those aspects, then please do get in touch, and I can certainly put you in touch with the right people.
Who will notify the MRO if the claimant requires a translator for the medical appointment? Do MROs arrange a translator at the request of an unrepresented claimant, or should approval be obtained from the compensator first?
So I've partly dealt with this already. What happens within the system is that the unrepresented claimant, as part of their journey and inputting their injury information, is asked through a series of questions around, where do you want to be seen, within what geographical location, is that the office, is that your home, do you have any special requirements, etc. So in giving the offer in the first place, MedCo will already have information around that type of need, and should only then be offering that type of a doctor that's able to help in a certain particular way. So we would anticipate that if this is going to happen and there's no doctor available, then there's very much an edge case. But for the vast majority of situations, this should already be catered for when dealing with the offer that comes in from MedCo.
Is there a limit on how many times counter proposals could be made on denial of liability in full case under 6.12, or does the 3 proposal rule only apply to admission of liability in part cases under 6.8?
Yeah, it's the latter. So it's only admission in part. There's no limit on the number of counter proposals where liability is denied. And a claimant needn't challenge the denial at all and can proceed straight to court. Or alternatively, if they've shared additional information at that stage, the compensator might change their stance, and, for example, move to a part admission. So the 3 proposals rule is, as correctly stated here, pointing at those part liability cases under 6.8.
Will the DME/MRO process and screens for retrieving an instruction responding to a challenge on a report and the report upload be shared at any point prior to go live, leaving this unseen until first instructed prevents appropriate preparations from taking place? Okay,
so I think I dealt with this one right up front in the sense that OIC are working with MedCo in order to help with training material generally. Now, that doesn't mean to say that OIC have responsibility for producing that. There's obviously a MedCo responsibility here, but we're working.
I do apologise, we have a problem with the audio. Please bear with us while we restart the broadcast.
Ryan, am I okay? Good morning, folks. I think we got interrupted then, but I understand we're now back online. Apologies for that slight technical hitch. Hopefully we didn't lose too many of you. I think, Simon, we got to 20, question 20, which was around the UMREP waiting out the prognosis period. Is that correct?
That's correct, yeah.
Okay, so before that interruption, I was just explaining that compensator actually doesn't see the medical report immediately. Unrepresented claimants actually have to do 2 things in order to release that report. They have to approve it factually. So as DMEs and MROs, once you see this process, you'll see that there's a short screen where you upload the report, and that report asks for some very basic information. The unrepresented claimant has a challenge factually. So I'm right-handed, left-handed, as opposed to anything that's non-factual, and it's only until such time as that factual content has actually been agreed and approved by the unrepresented claimant, and he's agreed to its release before the compensator gets to see it. So an unrepresented claimant could actually choose to wait out prognosis before authorising release of the report. It could be a gap in between the report being in existence and the compensator seeing it, which is the same issue that we would experience in relation to a represented journey, where obviously the system will be that the CMC, the professional user, the lawyer will actually upload that report, but obviously there will be a discretion on them as to when they choose to actually present that claim in that fashion.
When can DMEs obtain access to the system for training and testing purposes?
Yeah, I think this is the same as the question number 19, really. So we're working with MedCo on it, and they will be producing that material and making it available. So I know that they're working hard on that at the moment, because I've got some of my team working on that with them, and they'll be producing material that will come out into the relevant domain very shortly.
For represented claimants, will the insurer retain contractual responsibility as now for payment of medical fees, and does the compensator have any additional parallel responsibility?
So for the first part of the question, yes. For unrepresented, we've actually already partially covered this. So remember, the compensator only opens the medical journey at the point of actually accepting full or partial responsibility of liability per question. I think it was 5 that was answered earlier. So at that point in time, the compensator will assume the responsibility, and again depends on you've got both represented and unrepresented claims wrapped up in that same question, I think.
Guidance from the MOJ says all DME expert types are able to opt in to provide services for LIPs, but MOJ rules say only GP and A&Es will be able to provide a service for LIPs for non-whiplash injury or mixed injury claim types involving both whiplash and non-whiplash injuries. Does this apply to DMEs?
Yeah, I try to unravel this question just a little bit, but essentially I think it relates to the fact that, you know, if you're a plastic surgeon, you're not going to be asked to look at someone's whiplash injury. So whilst DMEs and MROs can all opt in, depending on their expertise, will depend on the type of work that they get, and then obviously lined up with the rules. But I think there is a little bit of confusion here about soft tissue and non-soft tissue injuries and represented and unrepresented claimants. So MedCo MOJ have said that the only experts who can actually provide a report when there's non-soft tissue injury claims are GPs and A&E consultants, and obviously that's whether the claimant is represented or not, and obviously that applies to IMEs, which will be instructed via MROs, just as it would be to DMEs. So that sort of base kernel of non-soft tissue and GP and A&E consultants are the core issues that sort of sit in the centre of that particular question. I think so, if I've interpreted it correctly.
After the initial go live in May, if there are any changes to the workflow, will existing cases automatically be transferred over to the new workflow? If not, how many compensators users know which version of the workflow a claim is on?
So there's no plans to integrate with the existing portal at all, or to transfer cases between them. So any case that's currently in Claims Portal will continue to run in Claims Portal. Any case that's actually raised in the OIC portal will continue its journey through the OIC portal. So there's no integration whatsoever between the two.
Do you envisage a large enough opt-ins from DMEs to provide a nationwide service of DMEs? The signposting for MROs should state that there is an increase in appointment availability. LIPs will become frustrated after selecting DME, then having to return and select MRO due to lack of appointments. Okay, so again, I don't think that I can particularly answer that question. I know that MedCo have posted various criteria, etc., into the public domain. I'm reliant on MedCo to do the work that it's charged and expected to deliver. I'm not expecting any issue in the service that MedCo does provide.
but you know, obviously as a question, it should probably be better directed into MedCo, who are probably unable to actually answer that question immediately either, because it's so young. But in due course, MedCo will be able to answer that particular question for you. Simon, I don't want to cut this short. I'm just conscious that we also want to spend 10 minutes looking at what next. So do you want to cut it there, and then I'll just deal with training access and next steps? And what we'll do, you know, that's the last 5 questions that we haven't quite got to, but what we'll do is we'll post those as we've promised with the to include in the top 30, if that's okay.
Yeah, no problem.
Right, cool.
We'll share that with the recording afterwards via our e-shots that everyone's subscribed to. Okay,
cool. So just bear with me one moment whilst I'm going to go back into a screen share, if I may. Yeah, it's my turn to panic now. Okay. So thank you for that. My apologies for closing down Q&A as quickly as I did. I was just conscious that our time was drawing to a conclusion. What I wanted to do was just to give you confirmation of what was going to happen next week in that training environment, which actually I think is sort of quite an important feature for all of us. So slide that you can see on the screen hopefully takes you through the sort of the basic steps that's going to happen. So if you are already registered on the system with us, you don't need to do anything at this point in time, because what will happen is that you will get access, you'll get a welcome pack that will either come out later this afternoon or tomorrow, with briefing packs with detailed instructions as to how you can access the training environment. We've set this up with IDs and passwords. They've already been auto-populated for you in accordance with your registration status. And what we're doing is we're looking at this from a compensator, a pro user, and an LIP perspective. You've seen the cadence, you've seen the rhythm of how this works. So it's not a training environment where I can give you an access as a claimant lawyer, as a compensator that takes you end to end. You're going to have to set up part of your team to do the here is my claim, and you're going to have to set up part of your team that answers it, depending on how you want to role play those different personas. If you don't do that, then you're going to get quickly stuck at the first point and not actually be able to answer what's actually being suggested of you. So in order to deal with that, what we've done is that we've set you up with those different personas, and your training teams will have to work out how you're going to put that into play so that you can act out those different issues as you go through. Portal Support Center is going to be open and available for queries. You know, you've already got the information, and I'll put up the contact details for you very quickly. But essentially, if you run into difficulties, please let us know. What I would do is just ask you for a little bit of forbearance. Obviously, we've got no concept whatsoever as to whether the 396 organisations that are registered to use the system all run into this environment on Tuesday morning, whether you're going to stagger that or how many people that you're going to have access the system. Behind the scenes, we've tried to second guess what that might look like. So we've looked at system capacity. We've looked at how we might have to escalate things if we do get busy, but equally from just purely an operational perspective, having to deal with queries from large numbers is also potentially going to be problematic for us. So we use the website. We'll keep you informed. We'll post what's hot, what's not. What we'll do as well is we'll monitor, high load periods and low load periods, and we'll put that information out so that you know that there's a better option at a certain stage. But we are confident that we've got the capacity. We are confident that we can actually welcome everybody on board that needs to use this system, because we are at a point where it will go live in 2 months' time, albeit the environment that's spun up for this training is not the real system. It is that training environment which is at a slightly taken down set of capacities. So we think we're okay, but obviously we'll deal with that as we go through. We've set up all organisations with a set number of access points and passwords. The passwords don't actually expire. All the information in here is going to be dummy information, and once we've dealt with the training access environment, we'll wipe all that down for everybody. So once you've got your compensator IDs and then your personas for professional users or litigants in persons, then those can be allocated throughout the organisation. We're doing this in blocks of 10, okay, because we're anticipating that training is likely to be structured. Now, if you're sitting there in a very large compensator, you're already saying, is 10 going to be enough? That may not be the case. If you think as you start your journey through here, that is going to cause you problems, then please let us know. But day one, we've looked at a one-size-fits-all model, and we will amend and allocate additional resources to you as and when we know that it's required. So that gets us up and running. What we'll do is we'll keep everybody informed on training program through FAQs, through websites, as and when our time together sort of continues during the month of April. If we need to get on calls because we've got particular issues that groups of people are dealing with, then we'll quickly try and spin up various sort of groups that are having common problems so that we can deal with those big numbers fairly early doors. But obviously, if you're able to just be a little bit patient, particularly next week as we go through this, that will be really helpful from our perspective. We've just taken on some additional staff in order to help with the additional contacts that we're expecting over this period. So hopefully we can marry those two things up and continue to provide the operational support that everybody needs. I just want to remind people of the contact details that if you need to any help on customer support, registering, accessing our service or integration via API, and for those of you that aren't on the eShot update, then there's information there in order for you to help with that. So hopefully those contact details are already cemented into your organisation, and we can help you continue the journey as OIC goes live, and we all face into the challenge that we've got around low value personal injury. There's one slide that I've managed to put in on the end of this particular deck that I mentioned earlier in the demo that I try and secure for you, and that was around the medical instructions standard form. We will, again, I'll share this with you as part of the sort of deck here, but this again is likely to be familiar for those that saw, for instance, the court form, and for those that have already seen in the demo list of losses, etc. So information being obtained and pulled through from material that's been input into the portal and then constructed in a very standard format, A, for the purpose of the doctor, so that the doctor is able to understand exactly what's being complained of, being asked very clearly whether or not there is a dispute that might go to, for instance, causation, and equally seatbelt usage is also covered within this form. It's a conditional form as well, so if there are no disputes, if there are no questions around those matters, then they don't appear here, but very structured and intentionally so, so that the unrepresented claimant can equally see this form and see what the doctor is being asked to do on behalf of the service. So I'd like to leave you with that, if I may. Whatever you're doing over the Easter break, if you are having an Easter break, have a great time. We'll promise to keep you updated and keep you informed. We'll continue to deal with responses as they come through to us, and we'll work through this one together, and we'll have additional conversations around material reflecting on the feedback that we get around FAQs, around questions to Slido, which we'll continue to hold open during the course of this event now, and look forward to catching up with you all during April and beyond. So thank you very much indeed.